lawyers qualified in Taiwan, New York, with PRC legal qualification. Bob has another identity. He is a non-resident researcher affiliated with Harvard Fairbanks Center. Next to Bob, we have Gavin, an international arbitration and cross-border dispute specialist, now partner at Charles Russell and Specialist, in Singapore, and formerly in Bangkok and Tokyo-based. So we have multi-jurisdictional expert and past chair of ICC Thailand's Commission on Arbitration. Next to Gavin, we have Trey Tong. Trey Tong is a Deputy Secretary General at the China Arbitration Institute, involved in China's arbitration law reform discussions and national arbitration credibility assessments, and expert in development in PRC arbitration. For those who may not know, CUPL, or the China Arbitration Institute, is a think tank that shapes China arbitration landscape academically and legislatively. So very interesting things for Trey Tong to comment on today. Last but not least, we have Kevin, a partner at Holman, Fenwick and Willen Dispute Practice in Hong Kong. He acts on complex arbitration and litigation across Asia, including regulatory and internal investigation. So the format of how we're going to run this panel is each of the panelists will have 5 to 10 minutes presentation on each of their specialists, and we'll go through them in turn, and then we'll have a panel discussion. So as the analogy was made between Gavin and I earlier, we'll each have a concert conducted by each of the panelists, and then afterwards we'll be running a karaoke session, which anyone can chime in at any time. So that's how we're going to run it. So the order of the presentation will start with Bob, who will be setting the stage for the most recent Chinese reforms, including economy policies that are happening around Asia, and how that may have implication in dispute resolutions across Asia, particularly in China and in Thailand. So Bob, you have the floor. Thank you.
Good afternoon. It's a great pleasure to be here. I have so many old friends and new friends. Thank you, Conference, for the kind introduction. So I'm Bob Zheng, and I get assigned with 3 very outstanding questions. So nowadays, right, in the era of AI, asking questions is more important than answers. I basically run AI to get the answers. Some of the questions I was not able to get good answer, so I decided to keep all the questions here, right, and keep this page here for a while. Then you know the questions, right? All right. So first, I believe you went through the whole day legal issues, so I try to touch upon less law, more on others. All right, then geopolitical pressures and this, right? And yeah, here are some books describing what where we are now, right? So it's the theory of Professor Clement Ellison from Harvard Kennedy School, right? So basically, number 1 country is facing number 2 country's challenge, and then conflicts can happen. The risk is higher, and that explains so many things happening now, right? So, you know, there is this saying, decades pass, nothing happened. But now, weeks pass, decade happen, right? Every day you have so many things, right? If you listen to Donald Trump's speech at UN, right? It's amazing. So you see every day, like, we are so busy, we know it's a very exceptional time, right? That's where we are. Southeast Asia, so David Sample actually make a measurement, like which country more close to China, which country more close to US, and you will find Thailand was put in the China side, right? And interestingly, if you look back a longer history, right, Thailand was right in the middle, but Thailand, Malaysia was more like on the US side, but then now shift the side. And Vietnam turned to, from very early country, one of the earliest country recognized PRC, now turned to more pro-US. Okay, let's talk about BRI, right? Because Kun Pun mentioned this Thai-China corridor, right? I search online, I search with AI, sit down discussing with AI. I was not able to find the official source of this term. So actually there is no official source of this term, right? You may hear China-Pakistan economic corridor, China-Myanmar economic corridor, but there is no China-Thai. The only thing you can find is earlier this year, February, Bai Hongtan visited Beijing. There was a joint statement. It mentioned China, Laos, Thailand, connectivity development, right? I guess that is the closest concept I can find, and I think Kun Pun probably mean BRI, right? One Belt, One Road. So some features probably you already know very well. BRI refers to China-centric connectivity projects, so basically infrastructure, and along with the connectivity under this big umbrella, you see railway, high-speed railway, highway, harbor, and surrounding the harbor, you see industrial park and all this, right? Logistic, okay, fiber, all right, and then factories coming in, right? And then to support this infrastructure, you have power and others, banking, right? And usually these projects are sponsored by Chinese banks or AIIB, right? Exim Bank or other commercial banks. So this is the full scope of a BRI project in Myanmar. These are some photos I traveled along the way. This is the Burma Road. Back to 100-something years ago, there was a reverse BRI proposed by Winston Churchill's father. So he tried to promote this idea that build a road to reach the southwestern part of China, right? And you see the Bank of China in nutshell this, like during World War II. And this is Thai. It's too small, I can't see. So basically, yeah, all right. If we look at Thailand's manner to BRI, right? Thailand is very pragmatic, and Thailand is so smart, bringing this idea, but integrate with Thailand's own agenda, right? Like EC, Thai 4.0, right? And try to shape itself to be the regional hub. And geographically, Thailand sits in the center of China. And Thailand did sign these two MOU, right? Actually, all the Southeast Asia countries signed MOU on BRI, right? And the flagship project should be the railway, right? The railway linking Laos, which is operating already, right? But the railway without linking to Thailand doesn't function like what China wants. All right. There are some needs in BRI and which touch upon. All right. So there are some projects existed before BRI, but when this concept was brought out, then people just put them under this umbrella. Right? But of course, there are some new projects, and then there are some official recognized projects, but there are some not. There are some self-associated projects. If you look at the Milwaukee Scam Center, right? In the very beginning, they claim they are part of this, but actually they are not, right? And there are so many others. And one thing you may need to know is different countries have different bargaining power in forming the projects. And each country has their own strategy, and some points people may overlook. One is the same size of project in different countries functions different, right? Let's say a railway project in Laos can eat up 20% of the country's GDP, but in Thailand can be just a okay project, right? Thailand is one of the country with good bargaining power in dealing with this, and also different projects may have different impact and not purely on the size of the project. For example, the Myanmar gas and oil pipeline, they supply almost 10% of energy consumption in China, and that is extremely important. And the Laos Railway, I guess now the function is it can carry durian to China and bring in Chinese tourists. If it doesn't link to Thailand and then all the way to Malaysia and Singapore, it just doesn't function the target, the goal China wants. And yeah, and there is a big gap between the project promise and the project realized. And then for tariff, I will keep it for later time to discuss. There's a big issue. All right. Second, we want to talk about supply chain shift, right? And Kun mentioned China Plus One. So China Plus One, we feel like it's actually last century issue. Now it's not China Plus One, now it's decoupled. It's totally separate degrees, right? China Plus One was this time, like 腾笼换鸟 time, right? It's because of China getting expensive. This picture explains everything. So this is an industrial park in Dongguan, in Yuyuan. This particular company, Pochen, used to hire half million people there. But now Dongguan is empty. And in this after COVID, post-COVID time, what people are discussing is not China Plus One. And the real thing you need to see is in Kunsan, right? The tech company left China because of relocation of supply chain. All right. So this relocation of supply chain has a few stages, right? The very early one was China getting expensive, so Wang Yang's Guangdong time, right? Empty cage and change bird. 10 minutes away, right? You sure? And then US tariff, and then different countries get different part of the supply chain, right? Vietnam get the tech companies, so a few iPhone components are made there, and then Thailand get EV, Malaysia, Singapore get semiconductor, and then you see like this shows that the change, right? The last question is very difficult one, and I will leave it to the speakers to discuss. Okay, let's look at some future picture because I'm running out of my time. So relocation of supply chain is real, it's ongoing, it's real, right? And for Southeast Asia countries like Thailand, is a historical moment for you to upgrade your industry, create jobs, create your mid-income class, and create your consumption power or consumer market, and that is very important. And one thing people may overlook is, and very few people touch upon this issue, is the demand of infrastructure remains high, right? But let's say if you see the supply chain from previously a vertical direction, China-centric, to now more horizontal, then your previous design of infrastructure may be changed. Previously, we designed the BI project more like the assumption that no matter what, you still need China, right? Some part of component was made in China and sent here, and assembled here, and sent back to China, shipped out to US, right? The story may be different now, right? You can use FDI, spend capital to build a railway, but you need commercial logic to keep it running, right? You can have a railway losing money every day, right? That's why the progress of Thai railway is so slow, and that's why Thailand does not have the intention to build, to link from Bangkok, passing down south, and then to Malaysia, right? Because in between you don't have economic center there, financially it doesn't make sense, right? And China remains significant to Southeast Asia, and Southeast Asia also get more other options, Japan, South Korea, and EU also proposed this global gateway. It's a special moment. I will stop here. I run out of my time. Thank you very much.
Thank you so much, Bob. It's actually interesting to, like, complete opposite of what I expected. So you're saying that it's supposed to be moving towards more China-centric, but it's not working as China has intended. And that was why the structure has been much more horizontal. That's how you have rightfully put it. And so Kevin will now be discussing more on the multi-jurisdictional enforcement. So now we have touched upon the economic, the policies, and the trends, the shift in relocation of supply chain. Kevin will be touching more on the actual enforcement, especially whether Hong Kong CETID awards are easier to enforce in China than awards in other jurisdictions. You also examine how regulatory investigations spill over to disputes. And then we'll tie them all in together in the Q&A session. So please bear with us.
Thanks, Brian. So I found it encouraging when Bob said that he couldn't find any official recognition of the Thai-China economic corridor, because neither could I, so it makes me feel a bit better about my research. And I guess that's not really a surprise, because economic corridors have existed forever, right? And we don't need an official stat. We can look back as far as the Silk Road or wherever, you know. And I think that's kind of, you know, going to be at the heart of what we're discussing today and what we'll look at now from kind of a dispute resolution perspective. And I'll just start with an example from a different economic corridor, the kind of the Middle East, China one, and an instruction that I got last week from a client in Saudi Arabia who import and distribute cars throughout Saudi Arabia, which is obviously a huge business at the moment. And they are looking to enter into a supply and distribution agreement with a Chinese manufacturer and seller. And so I got sent this distribution agreement, and they said, we need you to look at this. So we opened it up and we looked. The first version, which had been prepared by the seller, said governing law is China, and any disputes will be governed by Chinese arbitration, doesn't matter which centre. The markup that I've been sent had all that crossed out and said, this contract is governed by Saudi Arabian law, and disputes will be resolved in the Saudi courts. And so I said, well, thanks very much, this is great, but I'm in Hong Kong, what has this got to do with me? And they went, well, we know it's not going to be Chinese law and Chinese arbitration. We know we're not going to end up with Saudi law and in the Saudi courts. It's going to be somewhere in the middle. So please can your team review this from Hong Kong law, an English law, and a Singapore law, and all those different arbitration centres point of view, and see if this agreement works. And that's kind of what we're looking at and what we'll be talking about here, because this is a really good news story, this economic corridor, because you've got the increasing economic activity between Thailand and China, and rapidly, as we've heard today, developing arbitration activity here in Thailand. And as Tom will talk about later, he'll talk about some of the reforms in China. And in the middle, we've got two incredibly well, and we saw some of the stats from previous sessions talking about the popularity of Hong Kong and Singapore as seats of arbitration in between. And so it's a great, so there's good options and good learning, and each option will be kind of different. So I'm going to talk briefly about 4 aspects of dispute resolution which are relevant to this corridor. So first I'll talk about the enforcement of arbitral awards, particularly from a Hong Kong focus, because that's where I'm based, and I'm sure that Gavin will talk about it from a Singapore point of view later. I'll also talk about interim measures in support of arbitration, because you might be in a dispute and it's important that we can kind of look to preserve assets and evidence, etc., while those disputes play out. And then I'll take a step back, maybe a step to the side, and talk about regulatory investigations, as opposed to kind of just an arbitration or a piece of litigation, but how they might spill over into arbitration. And then we'll talk about third-party involvement in some of these disputes because that's on the rise and that's something that's particularly relevant in some of these corridors. So first of all, let's talk about enforcement. Why is it important? Why is it something we need to think about? Well, thinking about it from an arbitration point of view, an arbitral award is only as valuable as its enforceability. Without an effective enforcement mechanism, even a really well-reasoned, a very nice, and very favourable award is worth nothing if the refusing party refuses to comply, or if we're in an enforcement, a place where enforcement isn't easy. And that undermines commercial certainty and investor confidence. And that's one of the very cornerstones of arbitration, isn't it? So let's talk about enforcing arbitral awards in mainland China, because that's obviously going to be something of great interest when people are doing business between Thailand and China. So looking at it from a Hong Kong point of view, since 1999, Hong Kong's benefited from an arrangement with mainland China regarding the reciprocal enforcement of awards between the two jurisdictions. And that arrangement was supplemented in 2021. And it's particularly helpful when the award debtor has assets in mainland China as well as in Hong Kong. And that arrangement provides a unique enforcement pathway that's kind of unique to Hong Kong. And it allows parties to apply for enforcement in both jurisdictions simultaneously. So that reduces delay and risk. And it also empowers the enforcing court to grant post-award freezing orders and injunctions against award debtors prior to the court accepting the enforcement application. Now this is a really kind of powerful tool, and the stats show that over 90% of applications for enforcement of Hong Kong awards in China have been successful. And in the last kind of 25 years since the arrangement came into force, over 300 Hong Kong awards have been successfully enforced in the mainland courts. And this dual track mechanism, it offers strategic advantages over jurisdictions which might rely solely on the New York Convention or local law. Now, I'm not saying that that's, if you've got any sort of Chinese element, you must therefore choose a Hong Kong arbitration, because it can cut both ways, and I'll talk about that in the middle. But, securing an enforceable award is only half of the picture. In many cases, parties will need urgent support prior to a final award being made, and that brings us briefly to the topic of interim measures. What are interim measures? Well, they're urgent temporary remedies that help preserve the status quo or protect assets while an arbitration is ongoing. And they're crucial because without them, parties can, the ship can sail, parties can suffer irreparable harm pending the outcome of the dispute and before the tribunal can issue a final award. And Hong Kong again benefits from a special arrangement with mainland China, and this is very catchily named the 2019 arrangement concerning mutual assistance in court-ordered interim measures in aid of arbitral proceedings by the courts of the mainland and the Hong Kong Special Administrative Region. Now, that's not a phrase. If you stayed awake through that in the last session of the day and before the drinks, then well done. But what does this arrangement do? Well, in short, parties can apply to the Chinese courts for interim measures to preserve assets, evidence, or conduct in mainland China, and they can do that through a Hong Kong qualified arbitral institution. And unsurprisingly, nearly four out of 5 applicants are non-Chinese parties. So, in a situation where you have a commercial contract between a non-Chinese and a Chinese party, and a dispute arises, which goes to arbitration, and arbitration administered through a Hong Kong arbitration and is seated in a Hong Kong institution and is seated in Hong Kong, that non-Chinese party can go and preserve assets, evidence, and conduct in China. Now that's a pretty powerful tool. And according to the HKIC, as of September last year, 137 applications have been filed since the arrangement came into force, with 91% granted, so comfortably more than half, and that's resulted in preservation of assets worth more than $3 billion US. So these are real tools which are kind of being used. But obviously it's worth noting the arrangement operates both ways. So Chinese parties can seek interim measures in Hong Kong. So if you're a party that has assets in Hong Kong, then you need to think carefully about that, but it's not necessarily always going to be the case. And I think, okay, so that's what I'll say on enforcement and interim measures. But, growing challenge along the economic corridor and looking at some of the activity that Bob's already talked about, the nature of some of the deals that are being done along the economic corridor. We're seeing more activity in the context of regulatory investigations. And often they're driven not just by the shifting supply chain, but also by geopolitical issues. And I'm sure we'll touch on that more at some point as well. And what is a regulatory investigation? Well, generally speaking, it refers to an official inquiry which is being conducted by effectively a government agency, and they're looking at whether a company or an individual has complied with relevant laws and regulations. And they can cover a wide range of issues, an increasingly wide range of issues, right? So it can be anything from anti-money laundering to bribery issues, data protection, cybersecurity, competition law and antitrust. And these have got significant commercial and reputational consequences for the parties involved. And these investigations can commence either by one of the parties to a dispute perhaps reporting one of its counterparties for, say, anti-money laundering concerns. They can be internally by whistleblowers. They can be under the regulatory authority's own investigation. When it commences its own investigation, it might spot an issue which arises during a routine audit. And sometimes via activity cooperation between cross-border regulators, and that's something we're seeing more and more. And these issues are arising in the issues that Bob's already flagged, so infrastructure, logistics, energy, and they can cause knock-on disputes, whether by way of arbitration or in the courts. So, for example, you can quite easily envisage a situation where a logistics joint venture operating in China that could be under investigation for anti-money laundering issues, and that triggers a dispute between the JV partners over a breach of warranties or reputational harm arising out of the JV agreement. Another matter that I worked on involved, that was a bribery case where that country's anti-bribery authority was prosecuting a company for bribery issues where the alleged bribery involved its third-party intermediaries in other countries. And those intermediary arrangements between the company under investigation and the third parties all had arbitration clauses. And what the company did, as soon as a red flag was raised in the investigation, effectively stopped paying its third-party intermediaries. Those third-party intermediaries started this whole kind of suite of arbitrations in various jurisdictions around the world, which obviously, which led to, protracted kind of arbitrations and disputes running in parallel with the expensive and long-running investigation. And what's the practical outcome of that? Well, it underscores the need for robust compliance frameworks in cross-border projects, properly drafted transaction documents, and well thought out governing law and jurisdiction clauses. And we're seeing more and more clients kind of proactively seeking advice as they move into these jurisdictions, as they enter into contracts along the various economic corridors, because people are becoming, and it's important that people do their due diligence. Again, this is not new, we're just looking at it in different contexts. And given the increasing risk and increasing frequency of some of these claims, particularly where you're maybe on the front foot in terms of looking at bringing a claim, parties are looking at ways to finance those claims, because disputes are expensive to run, and as much as we love to receive fees, then it's not always the case that people like to pay them, and so what we've seen is this increase in the rise of third-party funding. And what do we mean when we talk about third-party funding? Essentially, it's when an independent funder agrees to pay some or all of a party's legal costs in exchange for a share or recovery of awards. And anyone that watches any kind of US legal TV drama will have heard of no win, no fee and all of this kind of stuff. It's essentially a much more developed version of that. And parties will enter into funding agreements with often very well-backed, very knowledgeable funders. And they'll do this to pursue claims that they might otherwise be able to afford, and they do that to manage risk and cash flow and to avoid tying up capital in lengthy proceedings. It also provides access to justice for parties facing well-resourced opponents. And that, I think, is of particular interest when we talk about the Thai-China economic corridor, where a lot of the parties that we might be doing business with are, say, Chinese state-owned enterprises or Chinese state-backed major corporates, which are obviously very well resourced. And so depending on where your arbitration clause, for example, is, may impact on the funding that you're able to attract. So in Hong Kong, for example, third-party funding is permitted in arbitration and related court proceedings. It's not available for traditional litigation outside of certain contexts, particularly in relation to insolvency proceedings, which can arise off the back of the enforcement of an arbitral award, but it's a conversation for another day. It's dispute third-party funding is well established in Singapore as well for arbitration, and it's certainly something that's worth considering as an option, when people are thinking ahead and looking at kind of what sort of disputes are. And so kind of stepping back, I think the takeaway is that when you're entering into a deal along the economic corridor is to think very carefully about, okay, and no one wants to think about how it could go wrong, but thinking carefully about how it could go wrong, what sort of disputes might arise, and then basing your governing law and jurisdiction clause, your arbitration clause, around those potential issues and looking at, okay, where might I want to enforce this award? Where are the assets located? Where are my assets located? How might the other party take action against me? How might I fund that dispute? Can I fund that dispute in that jurisdiction or under that jurisdiction clause? So lots of issues to think about, but the good thing, and I think one of my takeaways from today, and from us talking kind of offline when we're planning this session, is that there are lots of options along this economic corridor, which is why I think there is going to be so much more activity, because it is going to be very, very robust, and there are opportunities to kind of be as protect your investment as much as possible. And I look forward to discussing this more now. Thank you.
Thank you so much, Kevin. I mean, it's very interesting to hear from Bob, firstly, how the supply chain, how there's a Chinese-funded investments coming into Thailand on these projects, not only Thailand, but the ASEAN countries. And then with that investment opportunities came a potential sort of as a source of disputes, and how Hong Kong, Singapore, and Thailand are sort of like the more well-placed jurisdiction as sort of like a venue or seat of arbitration, given how Kevin has helpfully told us earlier that Hong Kong has a mutual assistance sort of like cooperation with China, and how non-Chinese parties have leveraged the mechanism to secure sort of like a preservation in China, which is very interesting. So Gavin, I'm very interested to hear what Singapore has to offer in terms of Thai, Chinese parties, and how that may have an implication on the enforcement of the award actually, in Singapore.
Thank you, Brent. I'll come on to Singapore in a little bit, but I was asked first to look at it from the Chinese perspective and how it would view arbitration in Thailand and for disputes and awards that have been procured on the corridor, how confident they can be to get justice and enforcement in Thailand. I've thrown away a lot of my notes because the previous session dealt with that. But let me just comment on it briefly. I first started working in Thailand in 2001. I was here again between 2014 and 2017, when the ramifications of the cases that were described in the last session so well about, and some of those government regulations which were restrictive about arbitration in Thailand, were still being really felt. I have to say, I think I'm more optimistic about arbitration in Thailand now than I was back in 2014 to 2017. Then and still now, I think the Thai Arbitration Act is still a decent bit of legislation. The previous session talked about interim measures and whether there needs to be amendments for that, whether there needs to be an emergency arbitrator provision like there is in Singapore and in the ICC rules and in Europe. I've always been less excited about those two aspects of arbitration. The underlying basis for the Thai Arbitration Act still provides a good framework for arbitrations in Thailand. So it's not, I don't think it's the problems with the Thai Arbitration Act, which means that investors and parties don't want to have their arbitrations here. That's not for me the problem at all, although I accept, as Conferece from Dr. Smith did mention, Section 9 of the Thai Arbitration Act is somewhat confusing about which court is supervising the arbitration and so on. But I don't think that's what's stopping investors arbitrating here, and wouldn't stop the Chinese arbitrating here. The key, as people have mentioned in previous sessions, is enforcement. And looking at it from a Singapore perspective, the trends are reasonable in Thailand. The courts, you saw on a previous slide, the courts have recently recognised and enforced foreign arbitration awards here, perhaps much more than would have been expected 10 years ago. The recent trends are favourable for that. So for me, whether you're going to arbitrate in Thailand, if you're a Chinese entity on the corridor, it's a question really, you're faced with the choice of can you enforce that award in Thailand, and are you better off, and are you more likely, which is more realistically, going to choose a neutral country? And that for me is the reason why Thailand will, for Thailand-based projects, Thailand will not become the preferred centre for arbitration. It's always going to be a neutral country, because that's the whole point of arbitration, is to have neutrality, and then you take that award from a neutral venue and enforce it against your counterparty's assets, usually in their country, if they haven't got assets elsewhere. So that was what I wanted to just say on the Thai arbitration scene. I think it's not as bad as it was 10 years ago, or even before that. But at the same time, faced with competition from Hong Kong and Singapore, Hong Kong less so, I'd say, these days, because of its relationship with China, but it's still a major force. It still has the most cases in Hong Kong, more than we have in Singapore and SEAC. So I think Singapore and Hong Kong are going to be where Chinese parties will want to have their disputes if they can get outside of China. And is that a bad thing though? No, it isn't. If we're talking about whether investment into foreign direct investment into Thailand is being encouraged, and if foreign parties, including Chinese parties, want to invest here, then they're not going to be worried about whether they can have an arbitration in Thailand. They will be more than comfortable with arbitration in Singapore or Hong Kong or elsewhere. So I don't think it's a bad thing that you have in the region very good centres with arbitration awards that can then be enforced in Thailand. Just look to see if there was anything else I was going to say. I think the answer to that is no. So turn back to you.
Kevin, you told me earlier, or it was during our call, that you were involved in, or you were consulted as part of when THAC was constituted, as in like when THAC was forms, essentially. What was the conversation then, and how have you seen it came so far now? So sorry, I promised that the Q&A session will be towards the end, but I just really needed to ask that question.
So I didn't in the end get into that because it didn't strike me as particularly relevant to Chinese corridor. But yes, when I was here in 2014-15, I was approached by THAC before it was set up, and asked, amongst lots of other practitioners in Bangkok, what would make a good arbitration centre and what should THAC think about when they were setting up the centre. From memory, having just at that time done an arbitration seated in London at the International Centre for Dispute Resolution, where the food was really good, I remember saying to THAC that Thailand is great for food and we must have really good food provided for arbitrators who are sitting here. And that's the most I can remember. But I did think that, and I did tell them on a more serious note, that with TAI being so popular for domestic arbitration, THAC had a real chance to position itself as the venue for international arbitration in Thailand. And I encouraged them to think of it like that, if they would be more the international centre rather than the domestic centre. I encouraged them to say, look, if you are going to be successful and establish yourself as a regular institution which parties will choose in their contracts, you need the support of the Thai government and Thai government-owned companies and big Thai private companies, so your PTTs, CP Group. If you can get them, when they have the negotiating power, when they're dealing with foreign companies, to force the foreign company to accept THAC, and you can establish a record of dealing with high-profile disputes, then it will snowball into THAC being a very well-regarded choice. And I think that's happened to some extent, but I think more could be done. And when it comes to the Chinese BRI investment, for contracts which are really between the Thai government and China, even if there are underlying parties which are representing those countries rather. So a lot of Chinese state-owned enterprises will be doing the investment into Thailand. On the Thai side, it could be the government, it could be a part government-owned company. That's the chance for Thailand to say, look, if this relates to natural resources or critical infrastructure, then there are justifiable reasons why they could be trying to argue for Bangkok-seated arbitration with THAC administering it. So I think there is a real opportunity there still for THAC to play an important role in some of the contracts.
Thank you so much, Gavin. So the reason that I pose this question right now is because we're transitioning to Shui Tong's input on how there is an up-and-coming Chinese arbitration reforms in terms of law and institution. So hearing how THAC have been and how it has become now would probably be helpful for context, just to set the scene for Shui Tong. So yeah, please go ahead, Shui Tong. Please tell us what's happening.
Good afternoon. Thanks for the invitation, and it's my honor and pleasure to share something newly happened in China. And my topic is the recent development of Chinese arbitration law and the enforcement of foreign awards in China. And just 11 days ago, the Standing Committee of People's Congress in Beijing has promulgated the new amendment of the Chinese arbitration law. And put it in a single word that the law is not making some new rules. It is rather a consolidation of existing practices. But I'm sure most of you are maybe not familiar with the Chinese arbitration law, so I have to give a considerable, swift, and necessary introduction to the Chinese law. First sentence I would like to say is China is not an ancestral model law jurisdiction. And the old law that was introduced 30 years ago in 1994, just 9 years after the completion of the ancestral model law. And back to that time, the Chinese legislator decided not to be an ancestral model law state. And 30 years later, again, we are not. And I would like to give three main differences between Chinese arbitration law and ancestral model law. The first one is the compulsory administration of arbitration institution. In China, in order to have your case be arbitrated, you have to name a specific arbitration institution in your arbitration agreement. Without designation of a specific arbitration institution, your agreement is invalid. And that is to say, ad hoc arbitration is not allowed in domestic cases. And the second feature, which is different from the ancestral model law, is the competence. The tribunal has the authority to decide its own jurisdiction, to decide whether the arbitration agreement is valid or not. But the court has a prevailing power to decide. According to the stipulation of the provision of Chinese arbitration law, it states that the one party asks the tribunal to decide, the party asking the court to make a ruling on the agreement, and the ruling of courts is prevailing. So, which is different from the ancestral and a lot of domestic law from the different countries. The third one is the interim measure. And according to Chinese law, the tribunal cannot issue a decision on the interim measure. So the party has to refer to the court, and the party has to hand the application to the arbitration institution, and then the arbitration institution transfer the application to the court. The court decides whether to approve and whether to enforce it. And these are different parts of Chinese characteristics, so-called. And the second distinguished feature of Chinese law is Chinese arbitration law consists of procedural law and rules on organization and regulation of arbitration institution. First, the Chinese law is compulsory involvement of arbitration institution, so it has to contain some rules on the organization and governance and regulation on the arbitration institution. And partly it is due to the fact that the domestic arbitration market in China has a very big size. In 2023, there are 600,000 cases accepted by Chinese institutions, and the aggregate amount of disputed case is 1.2 trillion RMB, of course. It's very huge. So there exists some unlawful practices in domestic context. For example, fraudulent use of arbitration against the third party. And the Ministry of Justice and the court has observed that and responded to that. So in this new amendment of Chinese arbitration law, there are a lot of regulatory rules on the institution are introduced. And the third part, which is different, which is Chinese characteristic, is China separates domestic arbitration and foreign-related arbitration. Domestic cases, party to domestic cases cannot choose to submit their case to a foreign arbitration institution and cannot choose law applicable and so on. And as to the procedural rules, the Chinese court applies just like the Article 34 of ancestral rules that China stated foreign-related international cases, the conditions to settle award is the same as the ancestral model law, but to domestic cases there are two additional conditions to allow award. There are concealment of evidence and fabrication of evidence. These two causes apply only in domestic cases. So, on this background, I would like to give a short introduction to the key changes regarding the procedure. First one is online arbitration. Online arbitration has been practiced a decade ago, since 2015. And the online arbitration includes not only the digital agreement, arbitration agreement, online hearing, and they can be managed, administered like in written form online. You can put question at this time and waiting the answer from the tribunal. Need not simultaneously, but there are a lot of this so-called hybrid system of online arbitration. So in this new amendment, the online arbitration is incorporated and recognized. And the second point is tribunal decides its own jurisdiction in accordance to the old law, and the arbitration institution has the authority to decide, which is strange. And in the practices a long time ago, the Chinese arbitration institution has corrected the law and conferred the power to the tribunal. So this time the Chinese legislator has recognized that and they correct their improper text, statutory text. And the third one is the duty to disclose, and duty disclosure in order to prevent conflict of interest such like that. And it is also a consolidation of the existing practices. And the fourth one is co-arbitrator appoint a chair arbitrator, which is a very common feature in international arbitration, but which is not that in Chinese domestic arbitration. So this time they kind of liberate and give power back to the party autonomy, and the party can appoint their co-arbitrator, and arbitrator appoints the presiding chair arbitrator. And in foreign-related or international arbitration procedure, now the ad hoc arbitration is formally recognized by legislator, and this practice is again is allowed by the judicial opinion by the Supreme People's Court. So it's not very it's a new not a new rule. It's just also implementation of pre-existing rules. And the sixth one is the seat is also a common conception in international arbitration, but in fact that back 30 years ago, Chinese legislators think the location of the arbitration institution is a connecting factor for the jurisdiction. For example, it gave rise to a lot of difficulties. For example, the ICC court managed a case seated in China, and the party has the difficulty to ask the court whether the Chinese court has the right power to set aside or he has to refer to ask the Paris court to set aside the award. But now everything's changed. We have adopted the conception of seat. And so the answer to the SAC court is the Chinese law. Chinese court has the right to allow the award. And the final one I would like to introduce, which is relevant to today's context regarding the investment and trade. And now, according to the rules on arbitrability of disputes, and they can only the commercial disputes could be arbitrated. And China has made a reservation on the New York Convention that only commercial cases award can be recognized and imposed in China. But the new law has introduced a rule that Chinese arbitration institution and the tribunal can arbitrate the disputes arising from the investor state investment disputes, which was and another part of this new rule is that China has adopted the restricted policy on the state immunity, and when the foreign state enter into arbitration agreement, and this should be regarded by Chinese court that the foreign state is not immune because they have entered into commercial activity. And so all of this gives rise to the liberation that Chinese arbitration institution can manage investment disputes seated in China. Okay. And as a contrast to the new amendment of Chinese arbitration law, that China, the state, has a policy to facilitate or promote Chinese arbitration industry, and in accordance to the survey conducted by my institute, that over 95% of contract entered into between Chinese and foreign party contains arbitration agreement. So the Chinese government knows clearly that arbitration is the basic infrastructure to foster international trade and development and investment. But the new law does not support that. But the Chinese government, as the People's Congress, has now empowered the local, the provincial or some like free trade pilot island like Hainan, the province can enact rules promoting international arbitration, can make different rules from the Chinese arbitration law. So I see a lot of potential in this this empower. And China has a wish to build some world-leading arbitration institution like THAC, and the THAC has also achieved a lot according to the 2025 survey of Queen Mary University, and the Beijing is the top 5, is amongst the top 5 states preferred by international users of arbitration. And the THAC, the rules of THAC is one of the top 5 preferred rules. And according to my observation, that this is resulted from the base the users Chinese with Chinese background has increased significantly. So their preference is THAC and state in mainland China. Okay. And as to the, I would like to have 2 minutes more. And the Chinese market for international arbitration is now opened up, and foreign institutions can have their branch established in a specific area like Beijing, Shanghai, and Guangzhou, Shenzhen, yes, and Hainan. They can expand their business presence in those provinces, and they can handle international arbitration and provide service to both China and foreign arbitration users. And the foreign lawyers is always available in international cases to represent their client before THAC or it's a long-standing practices. And foreign arbitrators is also, there is no, after the new law, there is no restrictions. Even according to the text interpretation, the foreign arbitrators can arbitrate domestic cases. So the market is opened up. And I believe the policies could help China to build capacities to facilitate the Chinese investors and foreign investors into China. So this is the hope and not the law, the new amended law. And okay, last minute for the last question. And as to the enforcement of foreign award, Chinese court is very friendly. I just like to refer to one mechanism, which is report and review system, which means in context of a foreign-related award or foreign award or award issued by a procedure city in China with foreign element, and the report and review system applies, which means when the lower court tries to annul or not recognize a foreign award, the lower court has the duty to report to a higher court. And the higher court has a duty when he tries to annul or refuse to recognize the foreign award. The higher court has to report to Supreme People's Court. So the Supreme People's Court has the final authority to decide whether to refuse or enforce the foreign award. So this, by concentration of the power into the Supreme People's Court, and China has a very relaxed and foreign-friendly, arbitration-friendly system to enforce foreign award. And okay, and two takeaways as to the enforcement of foreign award. First one is the violation of mandatory rules of China. Chinese law is not equivalent to the violation of public order, and there are rare reports on the non-enforcement of foreign award by the cause of public reservation. No, this is very few. And but the practitioners had to pay attention to the last one. That I just give an example. When Chinese court rules the arbitration agreement is invalid, and the award resulting from the agreement administered by or even stated by foreign state, the award cannot be enforced due to the integrity of judicial sovereignty. Okay, that's all. Thank you.
Thank you so much, Ray Tong. That was very interesting, and you'll see that I've made so much notes. this is honestly one of the first times I've attended, sort of like info session on Chinese updates, particularly on the arbitration law, and that's been very interesting, very helpful. David, I think you wanted to say something.
Is this on? Yeah. I just thought I was going to ask, and you came to on the last couple of slides. I think it was about 15 years ago when China introduced the idea that the Supreme People's Court had to review and approve any refusal Is it longer than that?
1990s.
It's in the 90s. So
1990s.
right. So for me, I first came across that in the 2000s, but late 2000s when I was in Japan, and it was regarded, particularly by the Japanese, as a major step towards comfort when dealing with Chinese counterparties and enforcing in a provincial court in one of the Chinese provinces. They thought that without that approval system from the Supreme People's Court, they would have very little confidence. And from a PR perspective, it seems to me that is a very good development by the Chinese. And then just tying it to Thailand, one of the things that was mentioned in the previous session was whether there should be a special arbitration court in Thailand. And I noticed it was on the survey that we've been asked to fill in. And it was actually the first time I came across it, because I saw this survey. It's question 11. Will Thailand be more attractive as a place for arbitration if Thailand had a special court to deal with the enforcement of arbitral awards? I think Mr. Balani is asking a bit of a leading question there, because he thinks it would be, and I have to say I agree. Even if that court, if there was such a court in Thailand that was specifically dedicated to arbitration and perhaps performed a similar function to that Supreme People's Court review to make sure that awards, foreign awards here, are mostly enforced when they should be, the PR value to Thailand of that for attracting foreign investment would be amazing. So I do think that is a real good suggestion that should be taken up.
So
Agree with that.
Straight on. So on the point, and Gavin's point actually on the Supreme People's Court, did I got the name correctly? Yeah, the Supreme People's Court. They will only review the refusal judgment to enforce the award in China, right?
Okay. Yes, the negative decision.
Just only a negative decision. Okay. Okay, I see. So that's sort of aligned with Thailand. So Thai practitioners, so allow me to chime in a bit on Thailand. So in Thailand, if you want to appeal an enforcement, a recognition award or a setting aside judgment of a Thai first instance court, you're only allowed to do so to the Supreme Court, directly to the Supreme Court, so you skip the appeal court stage, which sort of affirms the expediency and the swiftness of arbitration, sort of like the spirit of arbitration. So I'm very, very happy and interesting to see that the Chinese jurisdiction have been adopting and gravitating towards the more arbitration-friendly front. Yeah. Bob, actually, let me come back to you, Bob. So earlier you were discussing the economic reforms, geopolitical pressure. I mean, you stated earlier that Thai-Chinese economic corridor is not a real word, and it's actually BRI, Belt Road Initiative. And I did a bit of Google search earlier and had ChatGPT summarize it for me. So Belt and Road is actually something that have been mentioned very long time ago, probably like in the 2010s. So why do you think it's relevant now? Like, what's actually happening? Like, what are some takeaways that you want people exiting this room know what is actually happening in terms of like the Belt and Road Initiative? It could have been like in Thailand, in China, particularly like what's happening. Can you like summarize as a seat, like considerations in the seat? So I would, if I may, break down the questions into twofold. So yeah,
that's very clear. So thank you very much. Yes, you understand.
Neutral being where the seat of the arbitration is different from the incorporation or location domicile of both parties in the contract. That's the basic definition of neutrality. I think it raises an interesting point. So if you have a Singapore company and a Hong Kong company interacting with each other, and we're always recommending Hong Kong and Singapore as the neutral venues, then what do you do if you've got a single? I think many law firms would perhaps resort to the very old days of saying, okay, well let's choose London or Paris as the seat of arbitration. But if you had ICC Bangkok or THAC Bangkok in that contract, and I was faced with that, with given that contract and that dispute, I would not really have any concerns anymore about whether I'm going to have a good, well-run arbitration in Thailand. Because as soon as I get the tribunal appointed, I'm pretty confident that I'm going to, if I can get a good tribunal, that we'll have a good arbitration, and to the extent we would need support from any court for interim measures or document production, witness subpoenas, we could still go to the courts in Hong Kong and Singapore for that. So I think the answer to your question is that the contract will probably end up being in Europe, but it wouldn't be a bad idea for it to be in Thailand at all.
Yeah, I'd agree with that, and I think you see the amount of exchange and discussion that happens between arbitration practitioners and stakeholders throughout the region, throughout the Asia Pacific region, and throughout the world. This is a global practice, and you see so much more activity down here. All the kind of work that Nikki and THAC are doing, hosting events like this, only serves to improve the quality of the offering. And then, as Gavin said before, you look at your bench of arbitrators. You look at the bench that's down here. It's quality, and it's increasing quality. So yeah, I agree with Kevin.
Thank you so much, Kevin. So our time's up, and today we have heard from Bob on relocation and supply and how that have brought investors into Thailand, particularly from China, and how that may have an adverse effect from how China has been. We have heard from Kevin. Sorry, always got to meet Kevin and Gavin. We've heard from Kevin on Hong Kong as a seat and how investigation has then spilled over into arbitration and disputes. We've heard from Gavin. We've heard from Gavin on how Singapore and Thailand has become or is the seat of choice, and how investors that have always been the case, including THAC history, and Trey Tong in terms of Chinese arbitration reform. And this has been very fun panel to moderate. So if the audience may be kind enough to give the panelists a big round of applause just to conclude the panel.